SJC-10762, Rosnov versus Molloy.
Good morning, counsel.
Good morning. May it please the court. My name is Richard Alfred, and I represent the defendant appellant. With me at counsel table is my colleague, Barry Miller. The sole issue before the court is whether Chapter 80 of the Acts of 2008, amending the state's payment of wages statute, Chapter 149, Section 150, by mandating treble damages for violations of the Wage Act, as well as the many other wage and hour statutes included in Chapter 80, is retroactive for conduct prior to the effective date of that act, July 13, 2008. The Superior Court judge ruled that the amendment was retroactive. She made that decision without the benefit of any briefing on the retroactivity issue, and that decision now stands contrary to the decisions of three other judges, actually the only three other judges who have ruled on this issue and who have ruled that the statute may not be applied retroactively.
Is that, I know about Judge Young in De Fiore. Are the other two
Judges Hinkle and Broussard. And those cases are cited in the record, Your Honor.
May I just ask a general question? Were treble damages available prior to the amendment?
Yes, they were.
They weren't mandatory, but they were available.
That's correct. And this court, in the Weidman case, following a line of cases that preceded it going as far back as the Dart case, and including Goodrow against Lane Bryant, found that because of the imposition of treble damages and because of the wording of the statute at the time, discretion had to be applied. The application of treble damages could not be made without a finding in the court, in the judge's discretion, of conduct.
So would you say that in this case, that if your view of the retroactivity is adopted, the result would be, as in Weidman, it would be remanded for consideration whether the judge should exercise her discretion?
That's correct. So our position is that the statute may not be applied retroactively for two reasons. First, because it makes a substantive change in the law and affects adversely the rights of the defendant in this case, the employer. And second, the legislative history of Chapter 80 doesn't support a retroactive application.
What if it did? What if the legislative history did support that?
I think that would be a constitutional issue, Your Honor. At the end of the Goodrow decision, this court said emphatically and without any qualification that the, and I'll quote, to do otherwise, and I'll put this in context, to do otherwise absent evidence of heightened culpability would very likely constitute an arbitrary or irrational deprivation of property and thus would be constitutionally impermissible. And to do otherwise in that context is to apply the heightened standard of liability applicable to multiple damages awards.
Now you've lost me. Are you saying that that mandatory treble damages raise a constitutional issue?
The question was whether or not the legislative history supported the substantive change in the law.
But I guess my question, which is a variation of the theme that Justice Cordy asked, is what if the legislature had explicitly said the SJC got it wrong? When we wrote that statute, we always intended it to be mandatory. And that was our intent, and the legislature, and the SJC erred in interpreting that intent, and we're going to exercise our prerogative to say, no, we always meant for it to be treble damages. Are you saying that they couldn't do that and say that, so that and then say it should be retroactive as a result?
Our position, which is not briefed because it wasn't argued below, is that is in fact unconstitutional and it raises serious due process concerns, both under this court's rulings and under the United States Supreme Court ruling in Landgraf.
You say it would be like and I'm not going to remember the name of the case, but when the legislature kept amending the tax statute a few years ago about refunds.
Correct, but I'm actually not familiar with that case, Justice Botsford. But a change in the substantive law that adversely impacts the rights of a defendant, an employer, or an employee that imposes mandatory damages. This statute imposes mandatory damages, no good faith defense, as, for example, in federal law.
So you're saying that all you need to show is one of the two prongs, either an absence of a legislative intent or a change in the substantive rights of the parties, and you're saying you've shown both. But all you need to do is show one.
Well, Justice Spina, I'm saying in this case, in this example, Chapter 80, by imposing mandatory treble damages, even if the legislature, in response to Justice Gantz, even if the legislature had expressly made that statute retroactive, that would have constitutional problems. I'm not saying that that's the case in general for all laws. There are other statutes that make substantive changes in the law, but that I could see, if the legislature intended it, might not raise constitutional issues. And the general test applied by this court is, step one, does the statute make a substantive change in the law affecting the rights of others? In this case, the employer. If so, does the legislative history support that law as being retroactive? Was there an express, and the statute and the cases are very clear to talk about a clear, express legislative intent. Now, in this case, of course, we don't have that. The legislative history here is quite clear that the legislature did not intend this statute to be retroactive. And the reason for that is the change in the language of what was then Senate 1059. That became Chapter 80 as the law was ultimately passed. And what happened was, along the way in the legislative process, but before this law was actually passed by either branches of the legislature, the bill was changed. The title expressly was changed.
Yeah, but they say that that kind of preamble language, which was done by the Rules Committee, is administrative. It doesn't necessarily reflect legislative intent.
Well, in referring to the preamble, actually, amici are referring to House 4663, which was a bill that was introduced in August 2006, a little more than a year after Weidman. And that bill had initially a clarification statement in the preamble. That preamble and that statement were stricken. Now, in this case, the Senate Committee on Bills in the Third Reading has actually broad discretion to make changes. And we don't know for sure, actually, and the legislative history doesn't reveal definitively that that's where the changes were made. But that committee, under its mandate, under the statute, is allowed to make changes for constitutional reasons. My contention is that when the bill was making its way through the legislature, it was reviewed, and someone, having read this court's decision in Goudreau in the passage that I just read, concluded that if the bill were retroactive, there would certainly be constitutional problems. There may be constitutional problems just by mandating without any defense, without any good faith defense. And so it's not just administrative, although that committee has the authority to make purely grammatical, textual, kinds of changes. But the mandate, again, also provides for constitutional changes that affect the constitutionality.
Don't even, I mean, I assume that constitutional changes subsumes substantive changes, whether constitutional or not. Is that? In other words, it isn't just grammatical.
That's correct.
The committee in the third, for the bills in the third reading can make substantive changes, whether required by they think it's required by the Constitution or not. Is that what you're saying?
Yes, that's exactly what I'm saying, Your Honor. And when you take a look, and we've briefed this extensively, the original title of Senate 1059, again, that's the bill that became Chapter 80 that we're talking about today, is titled, An Act to Clarify the Law Protecting Employee Compensation. That became, in the new law, an act further regulating employee compensation. The clarification wording was removed. Second, Section 8 of the original draft, and again, when a bill is introduced, as we know, it represents the intent of the senators who sponsored that particular piece of legislation and nothing more. So that bill, the original bill, Senate 1080, had a Section 8, the last section, that said this act is intended to clarify the existing law and to reiterate the original intention of the general court that triple damages are mandatory. That section was eliminated, was stricken, just as the preamble in House 4663. And by the way, I think it bears noting that unlike the situation in Swift against AutoZone, this bill and its predecessor, House 4663, were not designated as emergency pieces of legislation, another indication of legislative intent for the statute not to be applied retroactively.
Of course, they might have been stricken because the legislature thought that they didn't need to put it in.
Well, Your Honor, I think that would be making an assumption that is nowhere supported in the record. And this court actually has said that where wording is removed from a statute, the court will not read that wording back into the statute.
But it was never in the statute.
No, well, I misspoke. A bill. If a bill is going through the legislature and it says X, as this did, the wording, the clarification wording, and that is removed, the logical inference is that when the legislature passed the bill, they weren't passing it as a clarification. If they had intended it to be, they would have said that. If that, the fact that they then removed that language, I think, is persuasive on the issue that they weren't intending it to be retroactive.
Can I ask you, the governor vetoed the 2006 legislation, no? Am I wrong about that?
Yeah, I'm sorry, yes. Governor Romney vetoed 2006.
And did that 2006 legislation have this intended to clarify language in it?
Originally, and that was stricken as well. That was in the...
That never made it to the governor's desk.
Correct. Never made it through the legislature. It was removed before the legislature passed that bill as well.
So was this bill identical to the one that Governor Romney had vetoed?
Identical. It was very similar, Your Honor. I haven't word searched the document.
Okay.
The key harm here, and I want to get quickly to the facts. I know my time is running short. In this case, a jury returned a verdict on a contract count of $173,000 for the plaintiff, Ms. Rosnov. By trebling automatically, without the ability to defend himself against the standard that was in effect at that time, the Weidman standard, that his conduct was outrageous, the judge automatically imposed treble damages, increasing his liability to more than $500,000, which happens to be more than $86,000, or more than 20% greater than what my client received as his portion of the fee for this tort case. Now, looking at that, that is a material, a substantial change in his liability. Another factor that the Fontaine Court reviewed.
Except you agree that the judge could have exercised her, after argument, could have exercised her discretion and come out with exactly the same result.
Typically, the judge would have held a hearing.
Right, but I'm just saying,
Yes.
you could end up at the same place.
You could, that it is possible, but the difference between having the being able to exercise the right to defend against treble damages rather than have treble damages mandatory without any defense possible is a material, substantive change in the law to great prejudice to Mr. Molloy and to others in his position. We don't have to speculate.
Thank you.
Thank you very much, Your Honor. I didn't see the red light.
Good morning. Attorney Jeffrey Mazur for the plaintiff appellee, Elena Rosnov, and I do have Attorney Rosnov here at counsel table with me as well. Now, there are two issues, as my brother has addressed, in this particular appeal. And the first is whether or not the change pursuant to Chapter 80 is substantive or remedial in nature. And my brother had sort of concluded by beginning to talk about the Fontaine case. And I would suggest to this court that the Fontaine case is quite instructive as to whether or not this change in Chapter 80 is in fact remedial or substantive in nature. And in fact, in the Fontaine case, that case dealt with General Laws Chapter 151B. And it talked about adding the provision of punitive damages to that statute. And prior to the change in the Fontaine case, punitive damages had never been applicable to a 151B claim. So what the court ended up determining in that determination was that because there was never a potential of being subjected to punitive damages, that that particular change would be substantive rather than remedial in nature. I would suggest to this court that with respect to Chapter 80, the circumstances are in opposite to that.
Well, I mean, Fontaine says legislation increasing the measure of liability, while arguably remedial in the broad sense, is considered to impair the substantive rights of a party. So let's assume we have two employers, one who negligently or unknowingly fails to pay accurate wages, or both of them having done that. One before the act and one after the act. The one before the act, the damages are limited to single damages. After the act, the same conduct is automatic treble damages. Isn't that a really substantial difference?
Well, I would suggest not, on the basis that that particular employer always knew that they could be subjected to the treble damages judgment against them. And in fact, looking, and I don't mean to skip around, but looking at the legislative intent of the wage and hour statute, it was always designed to be a strict liability statute. And in fact, as is addressed in both the Massachusetts Employment Lawyers amicus brief as well as the Greater Boston Legal Services brief, they talk about the reasoning behind having these treble damages, because when you're dealing with wages, there is a, for lack of a better term, a snowball effect that can happen to these employees as a result of not receiving their wages in a timely manner, and that the legislature was in fact trying to encourage employees to move forward and pursue their rights. So there was always this intent of having this treble damage potential in this legislation. So I would suggest...
But he doesn't dispute that. Your brother doesn't dispute that. What he's saying, I think, is that prior to the enactment of this statute, he at least had, or his client at least had, the opportunity to show that if he acted in good faith, he wouldn't be subjected to treble damages. Now, that's gone. It's automatic.
Well, I would suggest to this court that it was not actually a defense that the employer had, but rather a burden that the employee had to demonstrate this reckless indifference standard. And I would suggest that the defendants are not being stricken from a defense in this particular instance, but rather the burden on the plaintiff is being made less onerous. It's being made to justify what the legislature always intended, that if, in fact, it's proven...
You say that's what the legislature always intended, but this court did not agree in Weidman. So, I mean, isn't that the issue, whether it is what the legislature always intended or not?
Well, I would suggest, and again, that the two issues are somewhat convoluted, but I would suggest that to address that answer, I think we would look at the language of Chapter 80 and what, in fact, the legislature put into at least the proposed bills that were ultimately stricken in the third stage. And some of the things that they talked about in those provisions was that very fact, that this was always intended to constitute mandatory treble damages.
But then it was stricken. So what do you do with that?
Well, I would suggest, again, as we've briefed, that it was stricken in that third reading, which we allege to be for grammatical errors, or in the event that those types of statements are duplicative in nature. And I would suggest in this case that it was likely that they struck that language because it was duplicative in nature.
But even if you're right about that part of it, you still get to the question, you still have to deal with the question of whether it changed the substantive rights of the parties. And your brother's position is, and he seems to have some force to it, that it has changed the way the cases are now being either prosecuted or defended.
Well, it is in the sense that the plaintiff no longer has that burden to demonstrate the willfulness or reckless indifference standard. But what I would suggest to this court...
Is that a substantive change?
Well, I would suggest it isn't. I would suggest that it is an application, a determination as to how damages are going to be calculated, and that is purely remedial in nature. That when the employer goes into these cases and has these allegations against them, they are put on notice. They understand that they have the potential of being subjected to treble damages.
So it doesn't make any difference now that an employer may have proceeded or dealt with his employee or her employee in a decent, courteous, fair manner. If he's wrong, he's wrong, and he's wrong 3 times over.
Well, I would suggest...
And that's not a change in a relationship of the parties.
Well, I would suggest that it is a change in the remedial aspect of it, but not the substantive aspect, because that individual or that employer always knows going into it they could be subjected to this. This is quite different than the change in the punitive standard in the Fontaine case, where punitive damages were never a consideration. Here, treble damages are always possible. And I would also suggest again, and I apologize for bouncing around, but it does go back to the legislative intent, that what is the purpose of this statute? And I would suggest the purpose is to give employees an incentive to bring these cases, to compensate them. We're not talking about regular damages. We're talking about wages. We're talking about people live off of wages. We talk about the fact that these wages impact not just their ability to get money, but their ability to feed their families. So it has much more of a snowball effect than simply any other damage you're looking at. And I would suggest that that's why these treble damages, at least our position is these treble damages are mandatory in nature. There's a strict liability statute here, and that's what the legislature had intended. And so therefore the employer knows that going into this.
But the issue is not what the legislature intended in 2008 as to whether there should be a strict liability statute. It is.
Yes.
The question is whether the legislature was saying going forward, we now write legislation which clearly makes it strict liability. Where does the legislature clearly state that it was always strict liability and that they are simply confirming an earlier misinterpretation by this court of what the original intent was?
Well, I would suggest again to the court that the language that appeared in that chapter, again, that was ultimately stricken in the third reading, but also looking at the timing of the events. As we know, there was legislation that was proposed in 2006. The Weidman case came down July 21st of 2005. Unfortunately, that was vetoed by then Governor Romney. But then the second proposal was then proposed in 2007, and ultimately, through the course of various edits, ultimately gets passed in July of 2008. So I would suggest to this court that the timing of those events demonstrate that it was, in fact, in response to the Weidman ruling.
Well, it may have been in response to the Weidman ruling, but that doesn't necessarily mean that it was intended to clarify that all along we meant this to be retroactive, simply that we now want it to be we now want it to be mandatory.
Well, I would suggest that there are two factors that point to that. The first is the treatment prior to Weidman. And we did cite several Superior Court decisions in our brief that demonstrate prior to Weidman, most of the Superior Court decisions were treating the wage and hour statute as requiring mandatory treble damages. And of course, after the Weidman decision, this discretionary aspect occurred. And then on top of that, the various versions of Chapter 80 showing and stating, using the language to clarify the statute, I would suggest demonstrates that they are putting out there that they always intended this.
Well, it is stated before, wasn't that language taken out before there was a vote?
It was taken out, Your Honor, and again, our position is that it was taken out in the third reading.
Yeah, but it was before the vote.
It was before the vote, that's correct. But we would suggest that in the third reading, it's based on grammatical or duplicative language. And if you look at the way the statute now reads with Chapter 80 adopted into that, it specifically says it requires mandatory treble damages.
Did the events in this case take place after the Weidman decision or before it?
The events occurred before the events happened after the Weidman decision.
Okay, so why isn't the Weidman decision a gloss on the statute that essentially controls the meaning of the statute for purposes of this employer?
Well,
regardless of what the legislature's intent was, that's the way we interpreted it, and that's the way they conducted their affairs.
Well, I would suggest because while the case is ongoing, we did have this change in the statute, and we do cite in our brief to the United States Supreme Court case in Bradley, which talks about when there is a change in a statute. And even though the conduct may have occurred prior to the change, the final judgment happens after the change, that courts oftentimes look at what the change is in the prior to the final judgment in making that determination. And I would suggest that that issue goes very much to the heart of whether or not the issue is substantive as opposed to remedial, because I would suggest that going into the trial, certainly he was aware that there was this change in the statute. He was aware that he could have been subjected to treble damages, and in fact was aware that potentially it could have been mandatory in nature going into the trial.
Does the Weidman case essentially take the question of the element of analysis? What did the legislature always intend? Doesn't the Weidman case essentially take that element out of the calculus for purposes of this case?
Well, the way that I read the Weidman decision is that it focuses on the language whether or not the individual may bring an action, and if they bring that action according to the language of the statute prior to the amendment, it talks about they can bring the action for the following damages, including treble damages. And this court determined in the Weidman decision that that may language basically left that issue to the discretion of the trial judge, and has been briefed in Mr. Okerman's amici brief. It talks about the fact that that may language may actually talk about the various options that the employee has in exercising the wage and hour statute. For example, the Attorney General's office has the right to retain jurisdiction and pursue this matter on behalf of the individual. The employee has the right to file a criminal action against the employer for this. And once the employee receives permission from the Attorney General's office, the employee has the option of bringing this matter to a private cause of action in the Superior or District Court. So there is some dispute as to what that may language may actually be referring to.
Does that matter now?
Well, I'm not sure it matters now.
Post-Weidman? Why would it matter now?
Well, I don't think it necessarily does, but if we're looking at what knowledge base Mr. Molloy had to anticipate whether or not he could have been subjected to treble damages, and again, getting back to that substantive versus remedial question, I would suggest that once the statute has been amended, it takes that doubt out of the picture. So he knew going into this trial that this statute had been amended.
But
He
going
knew-
into the trial, we're talking about conduct that occurred before, right?
Right, but I would suggest that when you look at the Bradley decision, it talks about the fact that once, if the statute is amended prior to the judgment of the court, that the common practice is for the court to follow.
Be careful of Bradley. If you haven't looked at Landgraf, which clarifies that we never intended to say that, we now make it clear that Bradley did not alter the well-settled presumption against the application of new statutes that would genuinely have retroactive effect. So Bradley was very much modified and explained in Landgraf several years later. So I wouldn't put all your eggs in that basket.
Sure. Unless the justices have any further questions, I'd like to rest on my brief.
Thank you, sir.
Thank you.